Now, everyone will be given 15 minutes. If you'd like, you can take a few moments to give an opening remark. If time permitting, you can give a closing remark as well. That being said, the floor is yours.
Thank you. Well, as I've spoken to, I think all of you at least once, others more than once, my name is Tom Brown. I've been a prosecutor here now in my 24th year. During my time, I've handled everything from I spent a year and a half in county court, moved up from there into felonies, handled general felonies. I spent almost 2 years doing nothing but sex crimes, child abuse. I was in the criminal unit. I've been a division chief where I handle the homicides in my division, a regular docket, as well as supervise other attorneys. At this point, for about 12 years at that spot. I've had conservatively well over 150 jury trials at this point. I'm proud of my record. I think over my time frame, I have a good reputation with judges. I have a very good reputation with the defense bar. Of the trials I've had, one of the things that I'm proud of is the fact that up to this point, could change by next week, but up to this point, I've not had a conviction reversed on appeal, and I'm very proud of that fact. I will point out that I do have some sentences that are coming back with a combination of the recent U.S. Supreme Court opinions dealing with juveniles who received a life sentence. And for those cases, juveniles who were convicted of first-degree murder, that we have to resentence pursuant to the U.S. Supreme Court Miller case and the Florida Supreme Court cases dealing with that, which one of them was my case. As well as I have 3 death penalty cases where we don't know where we're at with those at the moment. Due to a recent Florida Supreme Court case, the new Florida statute, we're waiting to find out. But one of the things also with the death penalty cases that I'm proud of is the fact I've had 3 opinions come out on my death penalty cases at this point, and I'm 21-0 there, so I've not had a dissenting vote on the death penalty cases. So beyond all that, part of, I think, with my experience, a very good trial experience, very good working knowledge of the evidence code, which I think is important to be on the bench. I've had some recognition throughout the years. I received from my office, amongst the awards, Attorney of the Year from my office. 2009, I received from the Brevard County Bar Association a Government Professionalism Award of the Year, which I'm very proud of. I just completed this month a 3-year term on the Grievance Committee with the Florida Bar, which was a very enjoyable time. The 3 years went much quicker than I thought, so I enjoyed my time there. And I think one of the things I want to point out that I think exemplifies the reputation that I have is one of the people that I've listed on my 10 references is Randy Moore, who's a longtime public defender, recently retired after, I believe, 35 years with the Public Defender's Office. I tried a number of cases, including 2 death penalty cases with Mr. Moore. We have a very good working relationship. I've listed him as one of my references. I encourage you to contact him if you haven't already. But it was through his nomination and his effort that I was on the Grievance Committee. He was the chair. He nominated me. And I'm proud of that fact that somebody that I've been in the biggest type of trial that you can have, a death penalty trial, battled with him. We've been in several week trials. I've tried other first-degree murder cases with him and kept that working relationship with him. He has enough respect for me that he nominated me to be on the Grievance Committee. So that's another one of the many things that I'm proud of in my career. I think I have a general reputation of being fair, being reasonable. I listen to defense attorneys, I'll hear what they have to say, and I make my decision. And I think overall that's the general reputation that I have. So with that, I'm more than happy to answer any questions.
Thanks, Tom. Dan, I'll start with you. Any questions?
Sure. Thank you for addressing the issues of professionalism and camaraderie with the public defenders and others with whom you've litigated. Other than what you said in your opening statement, I was interested in asking the question about examples of where either defense counsel or judges have noted your professionalism.
What I can say as far as that, I believe I have a good relationship with the judges. I have had, for instance, retired Judge Silvernail. He was who I was in front of in county court many years ago. When I received the promotion to felonies, he wrote, which I still have, a very nice letter to me to the late Mr. Wolfinger, who was the state attorney, my boss at the time. I've listed judges as my references. The ones I've spoke to, they were more than happy to be listed. They continue to call me to see how things are going, if there's anything they can do to help me. So I believe I have that. In addition, through my years, what I will point out is I've had many occasions where the attorneys that I supervise and the public defender or some of the younger private attorneys, they've had issues where they're legal issues, say whether it's a decision on how exactly does this go in the score sheet, or do we apply legal status or apply these other types of legal issues. And both will come to me and ask. And over the years, the answer that I give, both obviously the attorney that I supervise accepts, but the younger public defender, the younger private attorneys accept, and I think that's the reputation that I have. And I've stepped in when I've had attorneys arguing issues with a judge where they're, I believe, misarguing or not correct on the legal issue, even though it's something that doesn't benefit the state. I've stepped in, I've approached the bench. I don't do it to try to embarrass anybody. I don't do it to broadcast to everybody that, hey, so-and-so may be incorrect on this issue. But I'll ask to approach the bench and inform the judge that actually my opinion is this is the law. This is how this has to be scored, how this has to be done. And I do that regardless of whether it helps my office's position or doesn't. Because at the end of the day, I'm fortunate enough in my position is my role is do justice. It's not win or lose. It's not achieve the longest or toughest sentence you can obtain. It's to try to get the best and the right and the just result.
Kevin?
Yes. What time will you start court?
Traditionally, I would say 8:30. I think I would start normal court 9, have at 8:30 to 9 o'clock. There's kind of a bond hearing type of session, any emergency hearings that need to be done. Have that kind of open because regardless of whatever spot that you happen to be practicing in, emergency motions come up. So I would like to have that 8:30 to 9 for there, have it freely open. Anything that comes up, I should be able to get in within a day or two if it's a true emergency situation. I do recognize, and I see this I think more often now than years gone past, there are a number of attorneys with child care issues. I can't be there until 8:45, 9 o'clock, have some of my division that we cover for and make arrangements. And obviously with a situation like that, those attorneys I try to accommodate and have their cases not heard until, if it's 8:45, 9 o'clock, whatever their situation is. But that would be my goal.
Thank you.
Andrew?
I just had one pertinent question and one just curiosity. What's a Stratomatic baseball league?
Stratomatic is a game that I started playing due to one of my older brothers when I was quite young. It's a baseball card game that's based on playability with statistical accuracy. And so each player, Major League Baseball player, gets a particular card based on their statistics. So when you enter the 2016 calendar year, which we're starting our season here in just about a week and a half, we play off the 2015 cards. It's an internet league. There's 28 people in it throughout the country. There's no money. Everybody volunteers for time. And for the ones who run it, it's quite a bit of time. And we keep a roster of 40. We have an $80 million budget. We have free agent signings, rookie drafts. That's kind of the nerd part in me comes out when I get into the numbers in baseball. So I love baseball, and that's a way for me to continue researching, looking at the numbers, memorizing numbers, learning the minor leaguers, and seeing like it's not a complete waste of time. It's actually productive.
So I appreciate the levity. And then going back to Judge Silvernail's letter, you indicated that you'd written the letter to Norm Wolfinger. I'm just curious about the substance of the letter. What did he state?
The letter was that, I hate to try to repeat all of it because he was very complimentary towards me. He indicated that he thought I was one of the finest attorneys that had practiced before him. He indicated he thought I would make a great felony attorney, that it was a very good move to be promoted. In fact, when he wrote it, and I was given a copy of it from my boss, it kind of choked me up a little bit. You meet somebody that was and is as well respected as he was, and is that he took the time to write the letter and had as many compliments about me. I always appreciated that. He was in my time here, even though it seems that most attorneys in my office switch from county judge to county judge, that was the only county judge I was in front of in close to 2 years. that I was in county court. And that was up in the old Rockledge Courthouse.
Thank you. Tim?
Good morning, Tom.
Morning.
Question for you. You're coming from a career prosecutor's side.
Yes.
And if you were appointed to this position, obviously you would be handling criminal matters and defense criminal matters. Can you address any possible bias that people may think you have in coming from the state attorney's office?
Well, I think the inherent bias that if somebody didn't know me and wasn't familiar with me would think that I would come in with the stereotypical prosecutor mentality, which is, I'm going to put people away, that's all I'm interested in doing, and I'm going to try to do it for as long as I can. But for the attorneys, I've been here long enough, I think probably anybody who practices criminal law is familiar with me over the years have had at least one case with me. I think the general reputation that I have is that I don't have that stereotypical prosecutor mentality, that I try to do the right thing, I listen, I look at everything, and I look at each case, what the defense gives me, what they tell me, what I can find out about the individual, and base my decisions on a case-by-case basis. That I'm not just, what's the most time I can get? Rehab a situation that can work. Are there other circumstances that explain the criminal behavior? And ultimately, for my position, my goal is to, maybe it's inherent laziness, is not have the person come back so I can reduce my caseload in the future. But I think ultimately, if we can stop the people, the individual, from committing crimes in the future, that's the goal. And throughout my career, one of the other things that I've done to try to address that is for approximately, that would have been maybe 10 years, maybe a little bit longer, I spoke between 1 to 2 months, or 1 to 2 times a month at our, what was called the JAS program, and then it became another name down the line, which was a juvenile offender program where first, sometimes second offenders, as a juvenile, we had almost a scared straight type of program set up. And I volunteered, it would be about 3 to 4 hours, 1 to 2 times a month, that I would go in and speak to those offenders. We'd have 60 to 70 in there along with their parents. We'd bring a police officer in, we'd bring 1 or 2 inmates in from the jail, and we'd bring other people involved in the system. And the whole concept was, can we reach them? Can we stop them now? Try to prevent more crimes in the future. And I think overall, that's been my goal from day one. And I think anybody who speaks to a member of the criminal defense bar at the moment, they're going to find out that that's my goal. I listen. I try to do the right thing, reasonable and fair.
Thank you.
Phil?
Morning, Tom, and
Morning.
welcome back.
Thank you.
I think up until now, we've heard maybe an emphasis on the criminal side of the county court, but there's also a big part of the county court judgeship that's going to be dealing with civil. And in that regard, you're going to have a lot of folks that are going to be there without attorneys, pro se's, type of individuals. And many times, it's going to be their first experience in a courtroom, and it's a system that's probably foreign to them. Can you give us very briefly what your insight will be, not as to how you'll rule, but how that you would handle it so that the people coming in front of you, especially those without lawyers, would feel that regardless of the outcome, that they got a fair shake with the judicial system?
What I would try to be, obviously, even if you had somebody who's pro se, the rules of evidence still apply to them as if they were represented by counsel. But I think you have to give them a little bit more leeway and try to help them work along the process to get in the evidence that they want to get in that should be admissible. They may not be doing it appropriately. So you have to give them perhaps a little bit of guidance and leeway in that regard. But beyond that, from the bench, I think you have to present yourself as somebody who's fair and respectful to those people. And over the years, I believe I've done that. I think most defense attorneys will tell you that I'm not up there with trying to disrespect their clients. They're still people. When those individuals come into, and county court would be small claims court, they're individuals, they're taxpayers, they're business owners, they're working class people. They're every aspect of society. every one of them deserves the respect, the time, and your correct rulings and your guidance to them. So I think I would show to them the same level of professional courtesy that I've shown to the defense attorneys throughout all of my years, the level of professional courtesy I've shown to police officers that I've had as witnesses, the other civilian witnesses that I've had over all these years. Present myself and run the courtroom with that type of respect, that type of demeanor, and help them work their way through the process. Hopefully I've answered your question.
Thank you.
No.
Good morning, it's nice to see you again, Mr. Brown. You spent a lot of years in the courtroom. Are there any thoughts or ideas that you have about making the county court more efficient in the criminal arena?
One of my term before pet peeves, which I think the biggest way to make courtrooms more efficient is you need to run in a timely fashion. And you can't, it's not running like a train. You can't say, we're going to start every hearing at this exact time, because sometimes things take longer. But from the bench, the things you need to do is make sure that hearings are moved along in a prompt fashion, but most importantly, that they start on time, at least from the morning. So if I have court set at 8:30, I need to be there at 8:30. There's no excuse as the judge to wander in at 8:35, 8:40. I expect the attorneys and the parties to be there on time. From my standpoint, if I'm lucky enough to be selected from this committee and the governor, there's no excuse that I couldn't be there on time. I think that's disrespectful from the court to be late. Likewise, during the time frame, if you take a 15-minute break, you expect all the attorneys, you expect all the parties, all the witnesses to be back in 15 minutes. The judge ought to be back in 15 minutes. There's nothing more frustrating over my years. I have an expert witness out where I'm spending taxpayer dollars, $300, $400, $500 an hour on this witness, and we're sitting twiddling our thumbs because a particular judge is taking a long, I call a soft 15-minute break, which may turn into 30 minutes, 40 minutes, or we're starting late because, for whatever reason. And it costs money. And attorneys, when they're in court, time is how they make money. That's the only thing they have is their time. That's what they sell. That's how they build. Likewise, the litigants or the witnesses. For everybody, time is important. For police officers, when they're in court, I'd rather have them out on the streets doing their job than sitting in the courtroom waiting for the hearing to be called. Likewise, litigants, if we're in small claims court, defendants, any witnesses, they all have jobs. They have things they have to go. They have to take care of their families. They don't need to be sitting in court any longer than they otherwise have to be. And if the judge is not in on time, you're causing all of those people to waste time and potentially lose money and affect their lives.
A couple questions, Tom. Thank you very much for your presentation so far. Do you remember when you were making an application, last time you were before us, I asked you if there was a county court position or circuit court position.
Yes.
Which one did you feel was best suited to your skill set? And I think you said county court, correct?
Between the two, I would prefer county over circuit, yes.
Right. Have you looked at the entire list of applicants today? I'm assuming you have.
Yes.
Okay. I know sometimes you have to say what's politically correct, but I'm going to ask you maybe not to do that right now. Distinguish yourself for the committee right now between the other applicants, and specifically maybe Mr. McMaster, who's got many years in your office as well.
Right.
So take this as an opportunity to say why we should pick you over your colleagues.
I think where I differ from the rest of the people that are on this list is my overall number of years as a practicing attorney, a number of years here in this county. As I said before, I'm going on my 24th year in the state attorney's office. So I have a tremendous number of years' experience. Along with that, I have, as I indicated earlier, quite a large number of jury trials that I've done. I have a very good working knowledge of the evidence code, of how to properly do a jury trial, which I think is invaluable to sit on the bench. Beyond that, I've been in the biggest types of cases that we've had. I've been in cases, I've tried cases that have had a tremendous amount of publicity. I've had court TV there filming every step that I do in the courtroom a number of times. I've had trials where I've had every local news broadcast in, and we have multiple cameras in. I've been in those type of high-stress, high-pressure situations. I've tried cases that have made national news, that have been covered at the national level. And I've been there and I've conducted myself throughout all of that in a very courteous and a professional and dignified manner. One of the last trials that I've done, a murder trial, was with three of the more prominent defense attorneys in this county, being Daniel Senior, Greg Eisenmenger, and Michael Ross. And that was with a defendant who had, in effect, unlimited financial assets. He brought in three different expert witnesses, two of them from geographically a substantial distance away from here. So I tried that case to a successful conclusion, but throughout it, if you talk to Judge Crawford, who was the judge in that trial, he will tell you throughout the entire time, despite certain defense antics, that I kept myself in a dignified and professional manner. We tried the case, tried it well. Greg Kineski was my co-counsel, and came to a successful conclusion. So I have that type of experience. Coupled with that, as I mentioned earlier, it's not simply a matter of going in, trying a lot of jury trials, winning a lot of jury trials. It's the fact that I've not had a jury trial reversed on appeal. A reversal can happen for a number of reasons, and sometimes it may have nothing to do with what the parties did. It may have been an incorrect ruling from the bench, but I've been fortunate enough that I've had good judges to try cases in front of. But I've also not done anything that would cause a case to be reversed, or said anything that would cause a case to be reversed. Beyond that, if you look at Mr. McMaster, to directly compare myself to him, Jim, that he's a very good attorney. I tried one case with him. It was the Deputy Barbara Pill, the murder of her, and which was a death penalty case, and obviously that received a lot of national attention. He's a good attorney, and I enjoyed working with him, and we made a good team on that case. Where I stand from him is, I've been here the full 24 years. I have, I believe, a larger and a more varied experience than Mr. McMaster does in this county and within the criminal justice system as far as the criminal cases go. He has obviously a civil background, but I've tried, I believe, more cases in my time frame than him, especially more bigger cases. Part of the reason that I sat with Jim on that case was he had not been first chair in a death penalty case before, so Mr. Wolfinger assigned me to that case. Obviously, death penalty cases are looked at with a fine-tooth comb, and any error causes a reversal. So that's one of the reasons why I was on that case. I've been a division chief in my office now going on 12 years, which I want to say, I think at that time was when Mr. McMaster was hired into our office. So I've been a supervisor, leading a team, supervising attorneys, having to criticize them, discipline them if the need arises for that lengthy period of time.
Tom, let me stop you there in the interest of time. Appreciate it. Any follow-up questions from any of the members? Thank you very much, sir.
Thank you.
We appreciate it.